useful for you to stop and think about that. First of all, you may not believe my claim that it's never been done before, but I can prove to you that it's never been done before. Because if it had been done before, if Congress had mandated that every American citizen do something, enter into an economic relationship with a private company, you'd all know that, about the mandate that had been imposed on you. If you all are residents of the United States, you would all know if Congress had imposed a mandate on you to enter into a relationship with a private company before, to engage in economic activity, because you'd all have to do it upon paying a penalty collected by the IRS. Since none of you in this room know that you have undergone such a penalty before and have been subjected to such a mandate before, that's proof that it's unprecedented. Now, why would that be? Why, given all the powers that Congress has exerted, why would it be that Congress has never exerted this kind of power before? Well, part of the answer to that question might be the few areas where the government does mandate that we do things, because it surely does. For example, it mandates that you register for the draft for selective service. It mandates that. It mandates that you sit on a jury if called for jury duty. It mandates that. It mandates that you pay your taxes. It mandates that. So mandates are not unprecedented. But what do all these mandates have in common? These mandates have in common, these are mandates rooted in the duties of citizenship, in the duties that people have as citizens to their government in return for the protections that the government offers them. So you have a mandate, you have a duty to participate in national defense, you have a duty to participate in the administration of justice in the course of being on a juror, you have a duty to pay your taxes, to pay for the services that you receive and the protection that you receive from government. These are duties that you have under the Constitution. To uphold this duty would be saying that the duty to buy health insurance from a private company is just like these other duties. It's a duty of the same order. It's a political duty that you owe the state. And I don't think it is. And I don't think the Supreme Court will find that it is. I don't think the American people believe that it is. And if it's not a duty of that magnitude, if it's not a duty of that order, then it's an unconstitutional duty. And that's the reason why it's never been done before. So why did Congress do it? If it's never been done before, why did Congress do it? Because this is how you do things on the cheap. This is how you offload costs and responsibilities. It was also a payoff to the insurance business, because there are a lot of mandates are being imposed on the insurance business, which can't be challenged as unconstitutional, unfortunately, because of previous Supreme Court decisions. And so the way to compensate the insurance business for the requirements that are going to be imposed upon it is to give them a whole lot of new customers. So what could Congress have done? Well, what Congress could have done is they could have enacted a general taxing and spending scheme like Medicare. They could have had Medicare for everyone, otherwise known as a single-payer option. And provided they didn't prohibit people from spending money on their own care, which of course Social Security doesn't stop you from saving for your own retirement, and Medicare doesn't stop you from paying for your own doctors and buying supplemental insurance. And as long as they didn't stop you from doing that, the courts would have upheld that. But that would have required that Congress raise taxes and then implement a spending program, and that's not something that Congress wanted to do. There was barely enough votes to do this. This is a way of offloading costs by making you give your money to this other person over here, rather than you give your money to the government. And so that's why they did what they did. And unfortunately for Congress, but I think fortunately for the American people, this is an unprecedented exercise of power. It is not justified by any prior Supreme Court precedent, and there's good reason to believe that there might be 5 votes to strike it down as unconstitutional. Thanks.
Thank you, Randy. Congressman, if the individual mandate is struck down, what is the practical effect, you think, on the legislation? Does the whole thing collapse, or is it like one of those monsters from the movies where you cut an arm off or a leg off and it just keeps on moving?
Well, the authors didn't put a non-severability clause in, which meant that if one part was held unconstitutional, the whole thing would go down. However, if the individual mandate is struck down, it takes the guts out of it. If you look at what's left without the individual mandate. Somebody could go without insurance until they knew that they needed to have an expensive medical procedure. And then they could go into these exchanges or whatever the government option is, have them pay for the cost of the medical procedure, and when the procedure was done and all of the rehab following the procedure was completed, then they would simply drop the insurance. Now, you can't run insurance that way when the only people who buy the insurance are the ones that know they're going to make a claim. And, I use the analogy back home. It's kind of like not buying homeowners insurance and your house catches on fire and you call 911 to get the fire department over there to put it out, and then you call up the insurance agent and says, I need a homeowners insurance policy effective at 12:01 a.m. today, and you'll probably get it if the insurance agent doesn't hear the sirens in the background of the fire department coming. So, you just can't run insurance when you know people are going to make a claim, and without the individual mandate, in my opinion, the whole deck of cards goes down.
Is that your view, Randy?
Well, yes, but you have to understand that that argument is, which is I think true, is a two-edged sword, because that is going to be the argument that's made on behalf of the constitutionality of this bill, and that is that it's going to be argued that Congress has the power to do whatever's necessary to implement a national scheme of a national regulatory scheme. In this case, it's a regulatory scheme over the insurance business, and this is necessary. So it's the very fact that the mandate is necessary for the various other mandates being imposed on the insurance companies to be viable that is going to provide the basis for the justification of the constitutionality of this bill under the necessary and proper clause, which gives Congress the power to make all laws which shall be necessary and proper for carrying into execution its foregoing powers, which would include the Commerce Clause power. So what's the answer to that? The answer to that first of all, has to be that, once again, this is unprecedented, never been done before, and it's going to require an extension of congressional power in order to do it for the first time. And the necessary and proper clause has also never been used to do anything like this before. So changing your focus from the Commerce Clause to the necessary and proper clause doesn't make it any less unprecedented. So that's the first answer. But the second answer is going to have to be that even though the courts are extremely deferential to Congress's judgment of whether something is necessary or not. And in fact, I think there's a very strong argument that the Congressman has just made as to why the mandate is in fact necessary to this particular regulatory scheme. It's not an implausible claim. On the other hand, the necessary and proper clause also requires that laws be proper, not just necessary. And there have been instances when the Supreme Court has struck down a law over a claim that the law was necessary and proper and said the law was improper, and there aren't many of them since the New Deal, but there are a couple. And both of them involve mandates. They involve, in this case, mandates on states. They said that it's improper under the necessary and proper clause to mandate that a state legislature enact a law. That's a commandeering of state legislatures. And they said it's improper to mandate, for example, that state executive branch officials, in this case it was county sheriffs, do background checks before gun purchases can be made. It was unconstitutional to mandate that the federal government mandate local sheriffs perform this federal function. So it was, in fact, a mandate that was held to be improper under the necessary and proper clause, but it was a mandate of states. It was not a mandate of individuals. But the fact that this is a mandate of individuals that's never been done before, once again, goes back to the point I was making earlier. Why are mandates different than other kinds of regulations? And I think that the answer to this necessary and proper clause argument is that this is an improper mandate. It's an improper commandeering of the general public is what it is, rather than an improper commandeering of the states.